Hello, good morning. Welcome to another version of Land or Home Immigration's Immigration Case of the Week. So today I'm going to be talking about a case called the Matter of Khan, which was decided on September 8th of this year, September 8th, 2016, by the Board of Immigration Appeals. All right, so imagine that you are in removal proceedings because you have committed a crime, and while you're in removal proceedings, you apply for a U visa. And imagine that you're applying for a U visa based on a pretty serious offense that you were the victim of, all right? You submit your packet to the Vermont Service Center, to United States Citizenship and Immigration Service. They adjudicate the U visa and they deny it, all right? They deny it solely because of the waiver. Okay, so remember, when we apply for a U visa, we can request a waiver of various grounds of inadmissibility, including criminal offenses. So now, you don't know what else to do. You ask the immigration judge to review the waiver that USCIS denied. Okay, so that's the scenario. If you're in that scenario, be careful, all right? So in this particular case, what happened is a man named Mr. Safraz Khan, he's from Guyana. He's a lawful permanent resident, and he was put into removal proceedings after a pretty serious criminal offense that he did. He was convicted of possession of pornography on his computer and a few other things, right, which are considered aggravated felonies under the Immigration Nationality Act. And so he was put into removal proceedings. They started and wanted to deport him, but he was eligible, at least seemed to be eligible, for a U visa. So his attorney applied for a U visa. USCIS denied it on discretion with the waiver, and then he did something very interesting, and his lawyer did something interesting. They asked the judge to review the waiver, okay? Now, the law says that some waivers can be reviewed in front of a judge, and some waivers, even for visas, can be reviewed in front of a judge. But there is tension, because the law and the regulations about U visas say that U visas are exclusively in the jurisdiction of USCIS and the Department of Homeland Security. So this question came before the Board of Immigration Appeals, and the big question is, can a judge, an immigration judge, review the waiver for a U visa, which is on Form I-192. And the decision that was published on September 8th says that no, unfortunately, they cannot. Immigration judges cannot adjudicate waivers of inadmissibility for U visas. So that is the holding of the Matter of Khan. That is the final conclusion there. And so what's the point of all this? The point is that if you're in removal proceedings and if you're eligible for a U visa, make sure to make your case as strong as possible from the beginning when you apply before USCIS, because if USCIS denies it, you cannot ask the immigration judge to review that decision. You have to win in front of USCIS. Otherwise, like Mr. Khan, unfortunately, you will be deported. Okay, thanks. So I'll turn that off. Yeah.